We've got a packed house this morning. That's great. We thank you for coming out to learn about advanced directives and learning how to make tough decisions, have difficult discussions. And this morning, not only am I pleased to see all of you, but I'm also pleased to introduce Kevin Mcardle. He is an attorney at the Campy, Mcardle, and Randall Law Firm, right downtown, right down the street, and we actually subcontract with him to offer legal services to folks like yourselves. And he's going to today talk about the healthcare end, the legal end, excuse me, of making difficult decisions. And then also pleased to introduce Dr. Daniel Root. He's going to be speaking on the medical end. So this will be very interactive, I'm thinking, based on previous presentations. So if you have questions, feel free to ask. And we are being recorded, okay? It's going to be uploaded to the county's YouTube channel. They won't see your face though. Okay, they'll just hear your voice. Except for YouTube, they will see your face. Okay? All right, thank you, everyone.
This is not scripted in any way, so we're going to just, as Dr. Root said, Dan, we're just going to come up here and we are going to start talking and see what happens. So now, I am wearing a mask, so it's probably not projecting really well. So can you folks in the back hear okay? Okay, because there's a couple seats up closer if you wanted to. You could come right up here and visit me if you like. But I'll do the best I can to try to project out there. I want to talk about healthcare proxies, and I want to talk about powers of attorney. And in the course of that, I'm going to also talk about maybe some living will information, or I just try to answer some questions about it too. So I think in your handouts, you have a healthcare proxy. And pardon the mess that I've made up here.
You had plenty of room. We'll just hear better. Thank you.
All right. Anybody else need to okay? I'm a little nervous about the county, finding out the county has a YouTube channel. Usually when I go on YouTube, I just watch music. I'm kind of intrigued to see what this is going to look like. Okay, the healthcare proxy. If you know me, you may know that I'm not exactly a fan of the New York State Legislature. I criticize them on a regular basis. However, when they adopted this healthcare proxy form in New York, they really did a good job. And this was back in the 1980s, I think, when they first adopted it. And it's a nice, simple form. It is it's a form that you really don't need a lawyer for. It's very straightforward, very common sense language, and I really like the form itself. Well, I'm hoping that some of you, anyway, got a copy of another healthcare proxy, which is one that with John Doe as the name on it. That's a power of attorney or the healthcare proxy that we use in our office, and we kind of tweak it a little bit to add some extra language. So I'm going to talk about the standard healthcare proxy first, and then I'm going to talk about our sort of long form healthcare proxy. So one thing I like about this form is it's short, so it's only a page and a half. The form begins with the person making the designation nominating an agent or a proxy to make healthcare decisions for them. There's some language in there that I want to point out. It says when you're pointing out your healthcare agent, right after that, it says to make any and all healthcare decisions for me. That might not seem like much, but that language, and I apologize for playing with this mask. I'm not used to talking and walking and masking at the same time.
If you're more comfortable,
Pardon me?
if you're more comfortable presenting without it, I think That's up to you, but,
Oh, I would much rather get rid of this thing.
yeah, I think you're far
Thank
enough
God.
away from everyone to
Okay, good.
present it. Yeah.
There, I can breathe again. There we go. Okay, I was talking about that language, any and all healthcare decisions. And that language was actually debated in the New York State Legislature. They wanted to make it as broad-reaching as possible. So it covers the usual stuff that you might be thinking about, like medicine or surgery, but it also encompasses other things that relate to healthcare as well, like psychology or psychiatry, and dentistry, anything that falls within that healthcare, which is a big range of coverage. So it's intended to be as broad-reaching as possible. So that was a good thing the legislature did. Now, the next sentence in there is also really, really important. It says, this proxy shall take effect when and if I become unable to make my own healthcare decisions. So, as long as, I'm assuming you folks are the appointers, as long as you are clear thinking, the doctor talks to you, okay? But if the doctor determines that you are either unconscious or not able to clearly make a decision, then the doctor can turn to the agent. It's not like you're giving up any powers at all. You are basically designating an agent only in the event that you become unable to make your own decisions. But there's one thing I want to point out to that is that decision about competency to make decisions, that's a tough, tough call, okay? And that's why you need really smart people to make that decision. Good luck.
Thank you.
So that's the healthcare proxy. The tough part about the proxy is when to make the call. But you have appointed an agent. Now, when you appoint an agent, you put not only their name, you put their address and their telephone number. Why do you do that? Because it might be an emergency situation. You might have to reach that agent right now. And so you put a telephone number at which you can expect that they're going to answer the phone and they're going to be ready to respond. And speaking of ready to respond, you should have conversations with your agent. Okay, first of all, let the agent know that they're appointed. So it doesn't come as a big shock when they get a phone call from the doctor. By the way, you're the healthcare proxy for your friend Bill. Who's Bill? So just make sure that you've had some conversations and you've at least discussed some of the basics. How can I say this without infuriating my wife? My wife and I have reached an age, particularly me, not so much her, at which we are having conversations like this with our children, and they are our proxies. And so we have basically had the last couple of weeks actually had some very serious conversations with them about what our beliefs are, what our wishes are, particularly regarding the issue of measures taken when there's no hope of our recovery, okay? And interestingly enough, we learned, I think, that my children have different perspectives on that responsibility. So that's important to know that, because you want to appoint a proxy who is going to have the strength to carry out what your wishes are. And it might come down to an issue of what sort of care you're going to be getting, end-of-life care, palliative care, being kept comfortable, that kind of thing. You want someone to have the strength to be able to say to the doctor, I think we've gone far enough. Or say, we've not gone far enough, I think we should go farther. Those are tough decisions to have, but try to have them with your proxy so that they are aware of where you stand, because you're stepping into the shoes of the person that's appointing it. Let's see. There is some language in here in which there's some, paragraph 3 is talking about that you can add in some specific language in here. You can say some specific directives. And I'll show you some in the long form that we use as well. Some specific language that we use to say, in this circumstance, do this. in this circumstance, do that. Most people don't do that, but we have included some sort of language in this long form that I think is helpful for a lot of people. Then now we turn over to the next page here, which is what you're basically signing your name. You're also, this form includes some extra language about organ and tissue donation. That's not part of the standard form. However, it's easy to add it in. And then New York State requires 2 witnesses for the healthcare proxy. And there's a couple of unique laws regarding the witnesses. First of all, the witnesses cannot have an interest. Well, there's 3 rules to be aware of. One is one of the witnesses cannot be the doctor. Okay, so that's because that would be a bit of a conflict of interest. Second, the witness cannot be a family member who has an interest in your death. Too much motivation one way or the other there, so that can't be in there. Then the third thing is, which I wouldn't have thought of this, but there's a limit on how many healthcare proxies that you can be a proxy for. And that seems like kind of a weird thing, but what New York State was recognizing is they didn't want that to turn into a business. They didn't want there to be like a commercial on late night television saying, hi, you need a healthcare proxy, I'll do it for you for $99 a month or something like that. They didn't want to turn it into a business, so they basically said you can only do, I think, 12 or something like that. So, so just beware of that. Before we move on to the long form healthcare proxy, are there any questions about the healthcare proxy or when it comes into play or anything at all? Oh, right there, okay.
You said not a family member with interests?
Yes. Like somebody that would be
Children
inheriting
would
if you
be-
died.
Interests, would have interest, wouldn't they?
Somebody would be, it's basically it's a financial interest, somebody that would have a financial interest if you died. What's the legal term is a distributee, someone that would inherit if you died. So that person can't be a witness.
Oh, a witness, right,
Just can't be a
okay.
witness.
Right. They can be a proxy. Oh yeah, hopefully I didn't say that, but they can certainly be a proxy. Yes, and they usually are. Okay, yep, speak up a little bit. I think there's some,
So, when you get done with these proxies, who gets these proxies? Like your doctor, the person that's gonna be your, or whatever, how many copies do you distribute where? or make sure somebody knows
great
where they
question.
are, or-
Where should these proxies go? Okay. The proxies should go, first of all, to your doctor, okay? And there's this thing out there called electronic medical records, EMR.
Okay.
And so when this goes into your file, this proxy should follow you wherever you go.
Okay.
So for example, I was a couple of years ago in a car accident in Alabama. We didn't actually have to go to the emergency room because we were all okay. But if we had, they would have put in the emergency room there, they would have popped me in there, the medical records would have showed up, and they would have known who my healthcare proxy was. And so that would have been my wife who was sitting next to me. So, so that's where it should go. You should also, again, there's nothing in the proxy form for the agent to be notified about this.
Okay, that's what I was wondering.
So you ought to notify the
Yeah, I
agent.
would think so,
So yeah, that's just kind of common sense.
Right, okay.
In the power of attorney form, that's one of the differences with the power of attorney, is that at least in the recent power of attorney forms, the agent actually has to sign the form consenting to be appointed. So, but that's not the case of the healthcare proxy. So the healthcare proxy, you should let your agent know. So again, they don't get that phone call in the middle of the night and they're like, what's going on? And also you need to have some conversations with them, some serious conversations, but you should also let your doctor know so it goes into your medical records and can follow you. The other thing about that is though, once you've done that and you make a change,
Yeah, that was my next question.
you need to do the same thing over again. So that if you've appointed a healthcare proxy, then you change your mind, you need to make sure that you follow that same path of notification so that there's not confusion as to which proxy is taking effect. And the most recent one takes effect.
Thank you.
Okay,
I've been finding that if you go to different doctors, take a copy of the healthcare proxy because it doesn't always follow you.
okay. I think that's a factor of this electronic medical records being built out.
Yeah,
It's happening right now as we're speaking. And I think our hospital was really on the cutting edge of that. We
Yeah.
were on the forefront of that. So it should be around here with all the local doctors.
but we had to have a procedure done in Carthage and they needed everything else, so we
Okay,
just carry it with us.
okay. All right. That's a good idea, is to carry one with you too, right? Yep. And the hospital used to give out those little plastic sleeves with a little tiny version of it in it too, which was kind of cute, where it would fit right in your wallet. I'm really tempted to say something about Carthage and slam how far behind Carthage is, but I won't do that. So, because this is being recorded and somebody might hear that and then they would take offense. So, okay, more coffee. I did bring with me what we call in our office the long form healthcare proxy. Some of you probably got copies, but I'll be honest with you, I wasn't expecting so many faces here, so I didn't make enough copies. So bear with me. But anyway, I have a healthcare proxy that is, if you did get one, it's for John Doe appointing Jane Doe, with the backup being Jack Reacher. Jack Reacher, of course, my favorite novel character who kills people at the stroke of his pen or something. So on this one, there's two additional paragraphs in here that I want to point out to you. I'm going to skip to the easy one first. We add a paragraph in here, and this is a paragraph in which the New York State Legislature should add this paragraph to the healthcare proxy. And it seems like every year in the legislature this comes up, but they don't manage to get to it. So see, I don't always say nice things about the New York State Legislature. This is one that they should do, but they haven't done. And what it is that it's a paragraph that addresses HIPAA. And HIPAA is the Health Insurance Portability and Accountability Act, something like that. And what it is, it's a federal statute, and it keeps your medical records confidential. So I can't see your medical records, you can't see mine. And the person has access to your medical records only if you give consent. So what we put in basically all of our healthcare proxies, we had this paragraph giving the proxy authority to have access to your medical records. Because it just makes sense that the proxy should be able to see the medical records. If they're going to be making a healthcare decision for you, they ought to be able to sit down with the doctor and have the doctor share the medical records with you, with the proxy, that is. So it's just that's something that I think should be in the standard form. Proxies should have access to medical records. But we put it in our form anyway, make that a standard practice. Any question about that part? It's pretty straightforward, I think. Okay, the other language that we add in there is language that basically boils down to statements saying that if you're ever in a situation where there is no hope of your recovery, that you do not want extraordinary measures taken to prolong your life. You would like palliative care. You want to be kept comfortable. And we have 4 paragraphs in there stating that as best we've been able to work it out. And we tweak them a little bit once in a while when we decide that this language isn't quite right. But these 4 paragraphs say that. Now, a couple things about that language. First of all, you may have heard of what's called a living will. And a living will is a document, it's a separate document from the healthcare proxy, and it is a document that says exactly what this language says. It says that if you're in a situation where there's no hope of your recovery, that you don't want extraordinary measures taken to prolong your life. And that's a living will. And many people feel that a living will is appropriate, so what we did is we just took the living will and put it into the healthcare proxy. So there's a couple things to be said about living wills. First of all, not everybody feels that way, okay? And a good example, or examples, are actually my parents. Both of my parents were nurses. Both of my parents had very similar professional experiences. They'd worked in hospitals. They had seen people die, and they had very different perspectives on it. My mother was perhaps a little bit more religious, and she would have said, when the Lord calls me, I want to accept, I will answer the call, and I will go. And she was very much a living will language person. She would have said, I don't want extraordinary measures taken to prolong my life. I want to be kept comfortable. I don't want extraordinary measures taken. My father, who had, again, similar experiences, had the opposite perspective. My father wanted absolutely everything done for him. He was not leaving this earth voluntarily, okay? So my father's favorite baseball player was Ted Williams. Anybody know who Ted Williams is? Okay, Ted Williams. Do you know what Ted Williams' family did with him after he died? They froze him. Yes, they froze him. He's in a cryogenic lab somewhere. At least I think he is. And my dad read about that and said, that's my hero. I want that. I want to be frozen. And then when he died of the same brain cancer that killed John McCain, it was a brain cancer that was kind of a web in his head and not really treatable. But he wanted to be frozen and then thawed out when they figured out a way to treat that cancer. So he did not want a living will. He did not want palliative, well, maybe he would have wanted to be kept comfortable, but he wanted absolutely everything done, even freezing him until they could thaw him out and fix him later. So, and just to let you all know, we didn't do it. So that probably when I go to the next life, he's going to be waiting and he's not going to be happy. But there's other issues we'll have to talk about first. So anyway, so some people feel about this living will language, the extraordinary care language, that it's appropriate for them. Some people don't. And some people are somewhere in between. So each one of these proxies, you need to kind of tailor it to the individual. They might want this, I don't want extraordinary measures taken. They might not. So yeah, that's something that we talk about with the client. We try to make sure they understand the choices. And then if they want the language, we propose this language. There are other examples of living wills. If you go on the website, the internet to, I think it's the Socrates Society. They are very much a proponent of this, and they have some examples on there, some different examples. We have a number of them in our office as well. So that's something to be considered is that language. But just be wary, that's a very personal decision. It's also a decision where you need to find a proxy who is strong, someone that can carry out your wishes. And that's what my wife and I learned in our recent conversation is our children, I think, have different strengths. I'll put it that way, because it's being recorded. I don't want to say any more than that. But they are, so we've named them as proxies, but we're hoping that they work together. So any questions about healthcare proxies before we move on? Okay. Oh, there's a question there.
Just one question, if you've got a proxy that moves all the time or changes their phone number all the time, like my brother, can you just go in and just adjust that, or do you have to fill out a new proxy every time?
Did everybody hear that question? If you have a proxy who moves and changes their telephone number regularly, should you change your proxy when they move? Is that what you're saying? Or
Do you adjust it, or do you have to fill out a new one?
you can speak to your doctor so that they could put something into the medical records that might track it. But to really officially change it, even the telephone number or the address or that kind of thing, you need to basically do a new one. And that's one of the advantages of cell phones, is that a cell phone will follow you. So hopefully he's not changing a cell phone on a regular basis, but if he is or she is, then they might have to do a new healthcare proxy. Any other questions at all? Okay. All right. I have no idea what time it is. That clock is kind of hard to read for me anyway. Okay. So I want to move on to powers of attorney. You should have in your hands a New York State statutory short form. This is an example of the New York State Legislature at its worst, okay? This is a horrible, horrible form. And I know I'm being recorded. Perhaps some legislative representative will hunt me down and try to point out the correctness of this. But I think you will agree with me as we walk through this form that this is a tragically misguided form. So let me just point something out to you. This is the Florida power of attorney. It's one page. Pretty good, huh? This is the New York State power of attorney as of 1991. It's a page and a half. On this new, the statutory short form, it is now 7 pages long. And they still call it the short form. What the heck is the long form? But this is their standard form in New York State. It just went into effect this year on June 13th, 2021. So one of your questions may be, if I already have a power of attorney, do I need to redo it because of this change in the law? And the answer is no. All the old powers of attorney were grandfathered in. So that's a good thing. But the dangerous thing is that on June 13th, New York State said, don't use the old forms, any of the old forms, use the new form, which so if you were on the 15th of June and you didn't know that there was a brand new power of attorney, you signed a power of attorney form and you used the old form, might not be valid. So just be careful of that. So we got to use the new form. There are some good parts in here. On the first page, I'm going to try to walk through this form with you, if that's okay. If it's boring, feel free to step outside and get a cup of coffee or something for a while and whatever. But I'm just going to walk through the form, and then I'm sure Dr. Root will have something more exciting to say to pick you back up again, okay? So here we are. The New York State statutory short form. It starts off with caution to the principal. This is a series of warnings, basically cautions to be careful about. So let's think about that a little bit. When you exercise a power of attorney, my friend Jim O'Rourke, who used to be the district attorney here, he used to call the power of attorney a license to steal, because that's what it is. When you appoint your agent, that person has access and can do anything that you could do with your finances. Okay? So if they're a good, honest person, you're going to be fine. If they're not, you've just given them a license to steal everything that you have. An example that you may recall was the North Country was lucky enough to have a supermodel in Watertown, Maggie Reiser. I don't know if you remember that or not. And she appointed, I think, her stepdad as her power of attorney. This was back 15 years ago or something like that. And he stole a bunch of her money. She gave him a license to steal. And he gambled a bunch of it away and spent it on all kinds of things. But she trusted him. And he legally had the right under this to do everything he did. At least between him and the bank. Between Maggie and him, there were some problems. But, so with that, I don't know if that ever got worked out. So that's a lesson, basically, is the most important decision regarding the healthcare proxy is to make sure that the agent that you appoint is worthy of the job, is trustworthy. Because if you appoint a good agent, everything's going to be fine. If you appoint a crook, it's hard to get it back when it's already gone. So just be careful about that.
We just had that happen last year.
You did.
His father was dying and he appointed a young girl and we can't prove a thing.
And as she was appointed as the power of
Oh,
attorney.
yeah.
Wow. Okay.
Thousands and thousands of dollars. We couldn't prove a thing.
Right. Right. And she had the legal authority to do what she did. Yeah.
Exactly.
It happens. It happens. And I've seen it enough times to be scared about it. But but anyway, this power of attorney is basically to try to stop that. And so they include all of these warnings in here. They include a bunch of other paragraphs that we're going to go through in a few minutes. And the intention of those paragraphs is to protect the person who is signing the form. So in Florida, their power of attorney looks like this. They basically say, you're on your own. You appoint somebody, that's okay. But New York State takes the attitude that we got to really protect people and warn them again and allow a lot of different things to be done to try to stop people from stealing. So it's two different attitudes, and somewhere in the middle might be the right one. But anyway, so
we're smart, we'd spend it ourselves.
well, I don't know if you heard that comment, but the comment was that if you're smart, and I know you're all smart because you're here, but if you're smart, you'll spend it all yourself. And that's my goal, is to spend my last dollar with my last breath. Yes, I'm not leaving a dime for those kids, but this is recorded again. Jeez, Connor, can you edit that one out? Sorry. Okay, thank you very much. All right. Okay, a couple things also about the form before we get started, and that is they use some language in here that is not totally clear. When it talks about the principal is the person signing the form, and the person that they're appointing is the agent, okay? They don't use the term healthcare, they don't use the term power of attorney really in the form and say, I'm appointing my power of attorney, because that's not really technically the way it works. The principal signs the form, the agent is the person that's appointed. So let's take a look at these cautions here. First caution number 1 says this is an important document. It seems kind of self-evident, but I prefer the word powerful. It's a powerful document because you're giving out power to steal. Number 2, when your agent exercises the authority, he or she must act according to your instructions. So you are still the boss. The agent has to do what you tell them to do. Number 3, your agent can only act after signing the power of attorney. That's a relatively recent modification to the form, so the agent has to sign the form. So that's good that they know they've been appointed, because it used to be under the old forms, the agent didn't sign the form. A lot of agents never even knew they were appointed. So number 4, you can request information at any time. So you can say to your agent, did you pay that bill? Did you take care of that insurance question? Did you do that or not? So that's important. Number 5, you can revoke or terminate this power of attorney at any time. This is so important, they put it at the beginning and then they repeat it at the end. And what they're trying to stop is the agent from saying to the principal, oh no, once you've written it down, you can't change your mind. Oh, yes, you can. You can change your mind. And it's really simple. You can tear it up. You can write revoke on it. There's no formal ways to record it, to revoke it, but you have the right to do it. This doesn't cover healthcare. That's under the healthcare proxy. And then if you want to look it up, there's a website here where you can find the form itself. Designation of agents is that's the bottom section of the power of attorney here. That little section right there, that's the whole power of attorney. If you went back 500 years ago or 1,000 years ago where a king was designating a lord to be his agent to sell some land in East Anglia, England or something, that's what it would look like. I, so-and-so, appoint somebody else as my agent. That's it. That's the whole thing. These are warnings. The rest of this form is warnings. It's basically saying, be very careful. So let's move on, and I'll try to get moving on a little bit. Next page is you designate your successor agents. Again, that's discretionary. You don't have to do that, but you can designate a successor agent. And then you come to the section that's called grant of authority. And this starts on page 2 and runs over onto page 3. And what it is, it's a list of powers that your agent has, that you are giving to your agent. In order to give any of these powers to your agent, you must put your initials next to the power. Now, most people put their initials next to the last one on there, which is letter P, which includes all of the letters above, all of the powers above. That's called a blanket power of attorney, and the intention of it is that it covers anything that might come up financially, okay? So could be almost anything. There's a couple of things on this list that I want to point out. First of all, letter I is personal and family maintenance. That has nothing to, that introduction has nothing to do with what this paragraph is about. Thank you, New York State Legislature. What it is about is it's the power to make a gift, okay? And in the old power of attorney forms, it didn't say anything about making a gift. This one right here that I have from 1991 didn't say anything about the power to make a gift. So what happened is some agents, including there was a case right here in Lewis County where an agent made some gifts on behalf of the principal, and then the principal died, and then the family members said, hey, where's grandma's grand piano? Where's grandma's Cadillac? And the agent's sitting there saying, I gave it away. And that didn't go well. Because there wasn't authority in the form to make a gift. So the New York State addressed that by saying, we're going to give you the authority to make a gift, but they put a cap on it. And in this case, they put a cap on it of $5,000 per year, which seems like plenty if you're talking about birthday gifts, wedding gifts, that kind of thing. But some people need to be able to make bigger gifts if they want to do some specialized kind of estate planning. You might want to be able to gift larger sums. And then there's a form for that in the next section here called Section G, certain gift transactions. But that paragraph is just basically giving your agent the authority to make gifts, but they put a cap on it of $5,000 per year. Any questions about that? It's kind of really fine-toothing it. Okay. The other one that I wanted to point out there is a new one that was added in here. Okay. Letter K, financial matters related to healthcare records, reports, and statements. This was added to the form relatively recently, and that's because medical billing, for those of you who've had any issues with healthcare billing in the last 10 years, billing is atrociously confusing. And so they wanted to make sure that your agent has the ability to basically address those questions that might come up. Healthcare billing it's a nightmare as far as I can figure out. But, okay, so when you're signing the power of attorney, you need to go through these powers and to decide which ones you want to give to your agent. Most people skip to letter P, which is basically covering everything. The next section there is paragraph G that talks about certain gift transactions. And this is where you can basically add in language saying, I want to give my agent the authority to make a bigger gift for estate planning purposes, or maybe you want to, maybe you've got a farm and you want to give away some bigger pieces of equipment, that kind of thing. Or you want to give away some cows, and that's a way that some farmers use to transfer assets over the years, as they give a little bit at a time to their kids. And that $5,000 might be too low. So we add that form, we could add language in there allowing them to make a bigger gift. The other thing that's not in there is the ability to make a gift to yourself. So if you want to be able to make a gift, you want your agent to be able to make a gift to herself, then in that circumstance, you have to add that into this gift transaction paragraph also. So it's kind of confusing, but this is the way New York State does it. Next is paragraph H, which is the modification paragraph. And this is basically, as it says in there, this is your opportunity to write some sort of specific instruction to your agent. Something you want to make sure is in writing so your agent knows it and will follow those rules. The example that I use facetiously with my clients is, if you want to say something like, don't sell my grand piano, then that's where you would put it, is right in here. Okay? I also tell people that if you have a message for your agent, it's a lot easier simply to talk to them and say, don't sell my grand piano, as opposed to putting it in here, because you can change it at any time then. But anyway, if you want something very specific, hardwired, written in here, you can do it right there. One of my favorite paragraphs in here is the next paragraph. This is the designation of a monitor, okay? And this is a situation where you trust the agent that you're appointing, okay? But you only kind of trust them. So you can appoint a monitor to keep an eye on the agent. And the monitor's job basically is to oversee everything that the agent does. The agent needs to get the okay of the monitor to do anything. I have never executed a power of attorney in which someone has appointed a monitor. If somebody said, yeah, I really want a monitor, then I would tell them, you don't want to appoint that agent, because the agent has to be somebody that you trust. So I've never had to use this paragraph, but it's there just in case somebody really insists on it. So compensation of agents, pretty simple. It basically says that the agent the agents serve voluntarily. They're entitled to be reimbursed for their expenses that they have. However, if you want to change that and say, I want to pay my agent $100 an hour, or $20 an hour, or $15, you can put an hourly rate in there if you want to. Acceptance by third parties. This is a paragraph that was basically, to my mind, was written not only by attorneys, but by a committee of attorneys who were, I don't know what they were doing. It's very hard to understand what it means. But let's try to see if we can figure it out. First of all, when it says third parties, the party of the first part is the person signing the form, the principal. The party of the second part is the agent, the person that's been appointed. A third party would be somebody like a bank or an insurance company or a broker or something like that. And this is saying that they will accept this form, because this is the standard form in New York State. But it's also saying in there that if you change your power of attorney, you have to go back and notify everybody who got a copy of the original power of attorney, because otherwise they're not going to know that it was changed. So they're just going to go by what's on their file. So if you make a change in the power of attorney after giving it to the bank, you got to notify the bank. Does that make sense? It's kind of common sense if you think about it. Unfortunately, the wording of it is not written in common sense language. It's written in legalese. Termination, this is the same language as was on the first page, where you have the right to terminate this power of attorney whenever you want. You can revoke it at any time. It's so important, they put it in here twice. Then there is the signature line, the notary clause, and the brand new part in here is, starting at the bottom of page 4, is this form now requires the signature of 2 witnesses. So it requires a notary plus 2 witnesses. So that's brand new. There was not required that you have 2 witnesses in the past. And Connor's not here, so we can't edit out my inability to turn the page. There we go. On page 5 is information for the agent. Have any of you ever been appointed as a power of attorney, as an agent for someone? Anybody ever had to do that? Okay, got a couple hands here. This page is for you. This page is telling you what your job is as an agent. okay? And there are 5 things that New York State thinks that you should know. Number 1, you have to act according to instructions from the principal. And that should sound familiar. That's also in the warning paragraph at the beginning. It basically says the principal is still the boss. So you have to follow their instructions. And then it goes on to say, where there are no instructions, you must act in the best interest of the principal. So this is kind of saying, don't steal the principal's money, but it's doing it in a different way. Number 2, you have to avoid conflicts with the principal. So I always like this paragraph where I can tell people that maybe a father's appointing his daughter and that kind of thing or whatever. And they said, this is now in writing. You must get along. No matter what your prior relationship is, you have to be friends from this point on. It's in writing right here. And some people, oh, that's good. We'll do it now. So number 3, you have to keep the principal's property separate and distinct from your own. That's just so you don't blur everything together and you can't tell whose property is whose. So you just try to protect yourself that way. Number 4 is also to protect yourself. And this is keep a record of any transactions. Anything you do as a power of attorney, keep a record of it. Keep a receipt so that you can, yep, I talked to the insurance company and I wrote notes of a conversation, something just to protect yourself. And number 5 is the most important one on this list. It's the most practical one too, because it's telling you how to sign your name as a power of attorney. A lot of people think that once they're appointed, they have the right to forge the other person's name. And that's not the way it works. You have to sign, the key thing to remember is when you're acting as a power of attorney, you have to sign both names. Doesn't matter which name is first or second, but you have to sign both names. And then you put POA next to your name. So you can put your name first, POA for so-and-so, or you can put the principal's name first and then your name second as POA. But the key thing is signing both names. You do not have the right to just sign your name as the agent, and you don't have the right to forge the other person's name. You basically have to sign both names and then disclose that you're the power of attorney. Any questions about that? Okay. And then over on the next page is a relatively recent addition to the form. And this is where the agent signs the form. And this was a change probably 10 years ago when the state first did it. It requires the agent to sign the form. And they're not just signing it. They are acknowledging that they are going to assume this responsibility and carry out the directives of the principal. So it's a little bit more than just, I'm aware, it's basically accepting the responsibility. And then there's a spot in there for a successor agent as well. And that takes us to 7 pages of short form policy. So anybody else feel that the New York State Legislature kind of overdid this? So if you think that, I just want to point out that New York State also includes suggested language for permissible modifications. This was part of the law as well. And this is another 5 pages of language that you can add to the form if you want to. And there's also what's called FAQs, frequently asked questions about the power of attorney. This was something unique in the law that they did this. It's not really part of the law, but there's more information in here about language that you can add in and why they did it the way they did it. So that's another 4 pages. And then there is the introductory language to the bill that came from the legislature that explains why they did what they did and what the changes mean. That's another 2 pages. And then there is this attorney from the New York State Bar Association, David Goldfarb. He is the expert on powers of attorney in New York State, and even he is kind of overwhelmed by this thing. But anyway, he wrote a whole bunch of possible changes you can make in the form and this kind of thing. And it's a bit risky because New York State says that you must use this form as the power of attorney in New York State after June 13th, and yet there's a lot of attorneys out there who are tweaking the form or tinkering with it in order to make it make sense. So It's not, it used to be really easy. In fact, probably 20 years ago, we did an Office for the Aging program like this. And so there was a room full of people, and we actually had powers of attorney, and we gave them out to people. And we basically, people signed them right there on the spot, because it really was like the Florida power of attorney. It was a one-page thing. You could do it. I just would notarize it, bang, away you go. It's not like that anymore. You got to sit down and talk to the attorney, think things through, get some do some analysis and thinking and some reflection before you can just sign it and go on. But that's, they just, and the whole purpose of all this extra language in there is to prevent the Maggie Reiser situations and to prevent the situation that you talked about. But really, the only way to prevent that is to appoint an honest person who will carry out your wishes. Other than that, all this verbiage in here isn't going to do anything. So I've officially run out of things to say. Any questions? Yeah. Okay, you're up first.
Okay, I'm a little confused and overwhelmed.
That's my job.
Yep. We did a power of attorney in your office in 2017. Okay, do we need to update it? Or is it grandfathered?
When did you do it? In
2017.
Oh, no, all those are grandfathered in.
They're great, so I don't need to change it?
You do not need to change it.
Okay,
Unless,
unless I wanted to.
right, unless you want to change who you're appointing or somebody like that,
No.
but there's, the form itself is fine.
Okay,
That was something they made very clear as all the old ones, even the ones way, way back from like the little short forms like that one, they're all good. They're still good.
okay.
But it is kind of tricky. This is something like that a bank has to do. So a person walks into the bank and says, I have a power of attorney. And the bank has to look at the date on the power of attorney and say, okay, from June 13, 2021, you're supposed to use this form. From 2017 to 2021, you're supposed to use this form. From 2017 to 2001, you're supposed to use a different form. And basically for the last 25 years, the New York State Legislature has been tinkering with the powers of attorney, and each time saying, during this period of time, this is the form that you have to use. So the bank, they have to go back and check, make sure that if it's like a 1992 power of attorney, did you use the 1992 form, or did you use an older one or a newer one?
Yeah.
Because you might have a perfectly good looking valid power of attorney, but it's not valid because it was the wrong form for that time period.
Okay, I think that was a question because, I can't remember exactly what the situation was, but I tried to show them, I think it was a bank, the one I had in 2017. And they said, this is gonna change, but I don't have to worry about that.
Well, whether you worry about it or not is totally up to you.
Yeah,
But but the bank has to accept that power of attorney because it was the right power of attorney for 2017.
okay.
So, but you can worry about it if you want.
No, I don't.
Okay, so don't, right, okay. You had a question?
So suppose you have an elderly parent that doesn't want a power of attorney. They have the healthcare proxy, but they don't want to sign anybody for the power of attorney. So what happens when this person, say, gets incapacitated or whatever, and nobody's got a power of attorney? What happens then?
That is a wonderful question. Everybody hear that question, or would you like me to repeat it? Maybe for the purposes of the recording, I should repeat
Because the elderly parent is
it.
too stubborn and doesn't want to designate anybody.
Well, let's not be judgmental about the, but let's just say, some people just don't know, or maybe they didn't think of it, whatever. But if a person approaches the stage where they can't make decisions on their own, they have dementia of some kind, or they're unconscious for whatever reason, and they can't take care of their finances anymore, and they did not have a power of attorney. Well, the legal option is guardianship. In which a person, probably a family member, would apply to the court to be appointed. And then the problem with that process is that it's complicated and expensive and slow. So because in the guardianship process, the court has to appoint an attorney for the alleged incapacitated person. The court also has to appoint somebody called a court evaluator, which is not necessarily an attorney. It's just a person that meets with the incapacitated person or alleged incapacitated person and files a report with the court saying, yeah, this person really needs a power of attorney, or rather a guardianship, but also puts limits on it and say, yeah, they need to address this bank account or maybe this kind of thing, but it doesn't need to cover everything else. They can still decide where to live, that kind of thing. So they try to, the focus on that is to do the least restrictive guardianship possible. So it used to be sometimes called a conservatorship, that kind of stuff. But this is the Britney Spears issue, the Free Britney. Yeah. She had basically a guardian appointed to take care of her finances, even though she was younger and that kind of stuff. But the court apparently felt that she didn't have the capacity to do it. So, but it can be a younger person, but generally it's an older person who has reached that stage. So yeah, it's the power of attorney. It's nice to have it in the back pocket and that hopefully you'll never have to use it, but it's a good form to have just in case. But the alternative is a guardianship proceeding, and even a simple one where the whole family's cooperating, that kind of stuff, it's complicated. And then if you have family that disagrees, Billy says this and Susie says that, then you may have a judge deciding some very intimate issues regarding that person, and it's not a healthy situation. So,
Thank you.
anything else? Oh, yep.
Could I just toss something out there that I found lots of people get confused about? So am I correct that my power of attorney can only make decisions for me while I'm alive? Financial decisions for me while I'm alive, and that has nothing to do with my finances after I've passed away.
Right. The power of attorney is a lifetime document. It is only effective during the lifetime of the principal. And that's a really good point, because I can probably count on all my fingers and toes the number of times that a person has come in to see me after so-and-so has died, and they say to me, I'm their power of attorney, I can take care of transferring their house, or I can take care of this, or whatever, that might be a bank account, that kind of stuff. And they can't unless there's some extra power out there. But yeah, the power of attorney begins when signed and ends at the death of the principal. So it is definitely a lifetime document. And then the will and the executor, that's the death time document, and the executor kind of plays the role of a power of attorney after that. But they don't overlap at all. Anything else? All right. May I just have a couple minutes? Okay. Turn things over to you now. What do you want to talk about?
Okay. At the risk of being politically incorrect, I'm going to take off my mask. I apologize.
All right, I'm going to reach in front of you and steal my coffee.
But I think I can speak better without a mask. Thank you, Kevin. That was fabulous. He stole a great deal of my thunder, which is excellent because he did a much better job than I could. My thought was that I would toss out some times in my experience when this has been important and helpful to me, just as examples of why these things are important. Because we don't always see into the future to see what kinds of bad things are going to happen. People don't want to be pessimistic and assume the worst. You read these things and my goodness, yes, I want to die. I don't want to die. And so they don't want to fill it out. It's a problem that people have an emotional hurdle to get over this. And I think if I throw out a couple of times when that's been interesting and important to me, it will help people overcome the emotional hurdle of filling out a healthcare proxy and a living will. I start with an elderly woman that I took care of in the nursing home. She came as a transfer to me from Callett's nursing home in Glenfield when it shut down. She came from downstate somewhere, no one knew where. We had no family. We had no old records. She was an elderly, demented woman who was going blind from her cataracts. And I wanted to get her cataracts fixed because she was walking into walls. She was sitting down on the wrong side of the arm of the chair. She was becoming a danger to herself from her blindness. And I was struggling to get her cataracts fixed to make her safe. But she wasn't competent to sign a consent. And I had no family member to sign it for her. I had no advice ahead of time, nothing written that said, please do this. And it took a very long time to work itself through the courts to get a guardian for her, blah, 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 blah. And that was very difficult. And this unfortunate woman ended up dying before we could get all that done. And I feel badly today about that because she didn't have a healthcare proxy to sign consent to get her cataract fixed so that she could see. There's example number one. Number two was a time when I was playing out in front of my house with my children. I lived right down the corner of Park Ave and Bostick Street. And I was out in front of my house and I looked up Bostick Street and I saw a car coming down the hill and starting to go off the road and bump into the curb. And I saw a gray-haired head slumped on the wheel. And it eventually hit a stone wall and stopped. And I ran over there and I pulled out of the front seat this well-groomed, elegantly dressed, white-haired little old lady, forgive me, who was not breathing, but who had a pulse. So I started doing CPR, and someone else stopped and said, I can do CPR too. And we were just like the movies, you know, pumping away and breathing. And the ambulance showed up and I stuck a tube down her throat and we got her to the hospital and she was, you know, got her blood pressure good and her heart was good, but she required the ventilator but she was not home and clearly had a major brain event because I could see her slumped over the wheel as she drove down the road. And we found her name in her purse and we found her chart and her chart said, no artificial life support. And that could mean two things. That could mean if I am terminally ill with an incurable problem, please do nothing. And I interpreted it that way. And so we stopped the ventilator and she died. I think she died half an hour earlier on Bostick Street. But it also could have meant I'm not terminally ill. There's some judgment that you have to have in there. A form saying no artificial life support doesn't necessarily mean under no circumstances do I ever want artificial life support. It could mean I got shocked by electricity, I fell down, and you can do something that will turn it around, in which case we do that. It doesn't mean deny me care. But in her case, I thought it was pretty clear she was never walking home. She was never driving that car again. And so that was a helpful thing to be able to say, she does not want this done. The third case was one that troubled me for a long time. I had a patient, lovely guy, strong, independent, lived by himself. I saw him because of some military-related complications that he had from his service years ago. But tough and independent. And so I never thought about making sure he had one of these filled out. And in hindsight, I should have, but I didn't. And he was out one day in the middle of January, shoveling his sidewalk. He was pretty good. He was elderly, but he was pretty good. And he slipped on the ice and he hit his head and he never woke up. And they got him into the emergency room. They shipped him down to Syracuse. Syracuse did what they could do for him, tried to deal with all the brain trauma from him hitting his head on the sidewalk. And 3 weeks later, he came back to our nursing home with a feeding tube in. But he was otherwise not at home. And I didn't have a piece of paper saying what this healthy guy would want, who slipped on the ice and hit his head. I didn't have a family member who had opinions. He had no children. He had no wife. I kept him alive in the nursing home, lying there in that bed for 3 years by feeding him through his feeding tube. And not once did he interact with me. Not once did he show a sign of sensitivity, responsiveness, anything. And I had to do that because I had no instructions to the contrary. Until a nephew showed up one day who knew him well and said, "What's going on here?" This nephew lived in Tennessee. I didn't know he existed. He said, "My uncle and I have been very close for many years. He would never want to live this way. Here are examples of things that he has said to me. They provided me clear and convincing evidence that this was not his intention or a desired outcome in his life. And given that, I felt confident stopping his feeding tube." And he lived for about 4 days and died. As far as I'm concerned, he had died 3 years earlier. But that whole mess could have been avoided by him having a healthcare agent nominated, by him having signed a living will, by him having had the conversation he should have had with his doctor, me, saying, someday, I don't want to be a vegetable. I want to be home, and if at some point I'm no longer competent, I want you to let me go. We never had that conversation, and I regret that. And so when people read these things and say, "This is so pessimistic, I'm healthy, I'm young, I'm strong, why do I have to fill out a healthcare proxy? I'm going to wait until I'm old." The lady with the cataracts waited too long and she wasn't able to make decisions. The guy who slipped on the ice waited too long and wasn't able to make decisions. You got to put on your pessimist's hat when you fill this out, saying this could happen to any of us tomorrow, and it could happen to any of us tomorrow. And if that were to happen, who would speak for me? Does that make sense? I don't want you to be that guy who slipped on the ice and fell and hit his head and lies in the nursing home for 3 years. I don't want to be that guy. But your father wanted to be that guy. And I had to assume that he had your father's values until I could prove otherwise. There's another aspect to these forms which are important, and that is that they bring peace, they bring resolution to your family. This is a very valuable thing for your family's mental health. Because I can't tell you how often I've heard a family member saying, I don't want to give up on mom. I don't want to be the one who kills her. I don't want to live with that guilt. My brother will never forgive me if I sign a piece of paper saying, don't be aggressive. People carry a lot of guilt. People carry a lot of family-related dynamics and disagreements. Filling out a form like this will help you bring peace to your family. And so, you know, the family member will say, that's not what I would have wanted, but we're doing what she wanted. And I don't have to feel guilty that I let her down. I don't have to feel guilty that we didn't fight for her to the last minute. That is a kindness to give to your family, is that peace of mind. And that happens a lot, that I'll sit down with the family and say, here's what, you know, your father wanted way back when. And then they'll come up with times when they said, yeah, he, you know, they come up with stories that would support that. And they don't have to go home feeling, I killed my father. Because we don't kill people. At least we really try hard not to. And I don't feel when I stop that guy's feeding tube that I killed him. I didn't kill him. I stopped providing artificial life support. Those are very different things. It was the fall on the ice that killed him. It was the head trauma that killed him. We don't have to provide artificial life support to people who don't want it. And we don't have to continue artificial life support for people who don't want it. And there's no ethical difference. And I don't believe, I'm not a lawyer, but I don't believe there's a legal difference between choosing to not start it or choosing to discontinue it once it's started. Those are the same. And it's okay to stop artificial life support if that's in the best interest of your patient.
You mentioned the standard, I'm going to pass to the clear and convincing evidence. That was language that you used, and you're right, I agree with you. There's no difference there. The standard is, do you have clear and convincing evidence that you're doing the right thing?
Yes.
And that's right. So I agree 100%. There's well, not to bore people, but there's case law that establishes that as the standard. And puts the burden on you to decide where that line is. Right.
Yeah. And it doesn't have to be from a nephew. It could be from a neighbor.
Sure.
It could be from their grocer. But it has to be from someone who had clear, intimate knowledge. And unfortunately, it wasn't me. And I guess it should have been me. But we're all human. And I sure didn't expect this guy to go. Nor did he expect it. So I'm going to encourage everyone to have a healthcare proxy, because everyone needs a healthcare proxy, because you never know. And I, forgive me, I don't want lawyers and I don't want judges making decisions about what you want. I want family members, I want loved ones, I want someone who you trust making those decisions. Not that I want to disparage lawyers, they're wonderful. But I would like to take them out of the equation as much as possible. And I suspect lawyers would say the same thing. Yes?
Hi, Dan.
Hi.
From a pre-hospital standpoint, people need to understand that we do not have to honor a healthcare proxy. Just so you're aware of that. That's going to be left up to medical control, whether they honor the healthcare proxy or not. Also, you have two types of DNRs. You have an in-hospital DNR and you have an out-of-hospital DNR. If it's an in-hospital DNR, we do not have to honor it. I just looked and I was sure of it. I looked up on my protocol. That's a medical control decision. It takes the burden off the paramedics and the EMT and puts it into doctors and hospitals have better lawyers and a lot more money to make that decision.
Thank you. That is a very helpful distinction, and that's
And
true.
I run into that a lot. Well, I have a healthcare proxy and we cannot honor it.
Right.
And we can call medical control. If the physician says, bring them in, continue CPR, that's what we gotta do. We gotta bring them in, and then the doctor makes, based on the information he has available, to decide whether to continue care or not.
Yep.
It's up to the physician.
Yep. And an out-of-hospital DNR, you don't have a copy of that here.
It has to be valid.
Well, Dr. Root, I think maybe this is a good time to talk about the most.
The most is what I would recommend.
Yeah,
Okay.
because I think that would be the document that.
That's what we
would honor.
recommend
Yeah.
with EMS. It gives us a clear direction of what to do. And we can honor anything on the most.
Not that white piece of paper that I stick to the front of the refrigerator
The
that says,
DNR, if it's valid, we can, but it has to be an out-of-hospital DNR.
That's correct.
Not an in-hospital DNR. And people get confused on that. Well, I've got a DNR.
Right.
You look at it, it's an in-hospital DNR.
and those are
Two different
different.
subjects.
Yep, thank
And
you.
that people need to be aware of that. It puts us in the heirs of the rifle if we have families that don't disagree on the care that should be provided.
Yeah.
But the intent of the law for us is to get them to the hospital and let the doctor make the decision.
And when in doubt, you need to err on the side of more aggressiveness.
Yes.
That's absolutely true.
And by the way, I remember that call. That was the guy that stopped with you, if you recall correctly, at the fairgrounds by your house.
Thank you for that. And as I recall, you gifted me a mouthpiece so that
Yes.
next time I could.
You had me do the chest compressions.
I still have that mouthpiece. I've never used it. This is a useful thing that the state puts out and promotes. It's hideous in color so that you can find it easily. It's easy to identify in the chart because they're always hot pink. I don't know why they picked that color, but it's a pretty hideous picture color. And if you want one, we have some of them over here. We don't have enough for everyone, but it's worth taking a look at it. And this is called a MOLST form, Medical Orders for Life-Sustaining Treatment. And this is generated by the state health department, so it has lots of legal support behind it. And at the top, it talks about EMOLSTs. EMOLST number. I don't think that they have electronic versions of this available yet. Last I knew, they did not, but that was a while ago.
Their website has it at one time where you go in and fill it up, and then it's in the system for statewide use. Even EMS with our cell phone, we can get into it. If you're in their emails, if you don't have the form present, it will be listed. You just have to ask for a driver's license.
Does it interact with the electronic health record of the hospital?
Yes.
Does it?
Yeah.
Oh, okay.
So a lot of larger cities are using emails. I don't think our health system has started yet, but it's like commonplace in Syracuse now.
Yeah,
In Albany,
I wasn't aware that our system interacted.
not yet, that I know of.
Okay.
But if they have it, on our iPhone, we go there, if we have internet, we can verify it if they don't have it in person.
Well, you're more tech savvy with that than I am then.
One thing I would suggest is that if they have one, say a person has one, is put it in a clear envelope and stick it on the refrigerator, because that's where we are trained to look.
This right here.
If
Yep.
you have someone go into somebody's house, there's nobody there in non-conscious.
Yep.
As a
Yep.
suggestion, that's how we were trained.
The standard place is the front of the refrigerator.
Yes.
Yep. And so section A says, do I want an artificial life support? Or do I not want artificial life support? That's pretty straightforward, although that's a little bit rigid for me, because it doesn't say here if there's no hope of recovery. And sometimes there is hope of recovery. So that's a little bit, this requires some interpretation, which is a little confusing. If you came into the hospital with a whopping pneumonia, and I thought I could fix that pneumonia, would I want to put someone on a ventilator for a day or two? I would. If you came in with a whopping cancer and couldn't breathe from that, would I want you to put you on a ventilator for that? No. So there's some interpretation that needs to go in here. And you have to be careful when you give a blanket statement, no, I never want a tube put in my throat. You have to interpret the subtleties of what that means. And hopefully your medical provider knows you and can help with that. Because it's not true that people who have a do not resuscitate order never get medical care. That's just not the case. You do what is appropriate given your particular situation. But there is a place here saying, I do not want artificial life support. If you come into the hospital, you would say, yeah, I want it now because I have pneumonia and I think I could get this turned around. And they would. Next page is more what kinds of things do you want to do? Next page talks about, do I want everything done? Do I want IV fluids? Do I want monitoring? Do I want only things to keep me comfortable and no other interventions? You can choose. There are people who say, please do everything, and we do. There are people who say, IV fluids are okay, feeding tubes, no. IV antibiotics are okay, surgery to take out my rotten gallbladder, no. There are subtleties in there, and you have an opportunity to express some of these thoughts. Do you want only comfort care? Do you want a limited amount of stuff, or do you want everything? Do you want, if you're going to have artificial life support, feeding tubes, pacemakers, breathing tubes, do you want to have that be permanent or just a short-term time for a matter of days or weeks or whatever your healthcare agent might want to stipulate? There are places here where you can choose this. How do I feel about feeding tubes? How do I feel about antibiotics? And some of these are fairly specific, and it's hard with normal, healthy, regular people like you to say, I do or I don't want this. There are real subtleties in this, which is why it's so important that you have a healthcare agent, so that when you can't answer, they can. But you could let some of your opinions be known in here, and that would be a comfort to your healthcare providers and a comfort to your family. And then the next page is just opportunities to renew it, because they think you're supposed to renew this periodically, to say, yes, I don't want, that this is still in force. The out-of-hospital DNR form that is often used instead of this, you're supposed to renew every 3 months, but it says right on it, it should be renewed every 3 months, but it's still valid if it's not. Because in fact, they never are. So somewhere in there, the legislature had some common sense. Hard enough to believe it as though it is. What else should I talk about?
Doctor, would you mind if I made a comment on the mulch?
Please.
Okay, so, my name is Crystal, for those of you who don't know me, I'm the director at OFA. Before I came to OFA, I had the privilege of working with Dr. Root and Kevin at Lewis County Hospice. And then I was at Jefferson County Hospice for a while, working with their palliative care program. And I think the best thing that I feel like as a social worker, I want to tell you about the most is that it's designed for people with chronic health conditions or critical health conditions. And it's designed to update it as you go. So you might have some serious cardiac issues and fill out a MOLST in consultation with your doctor. So you always fill out a MOLST with your doctor. And they help you. The idea is that you sit with a doctor or a nurse practitioner or a physician's assistant, and they help you make the decisions around care that you want to receive or that you don't want to receive. And it's designed to say, yes, I want life-saving measures. I'm okay with a feeding tube, but I would never want to be intubated, right? So you're thinking about your health, your spiritual and personal beliefs to fill that MOLST out. So then you get a little bit farther down the road with your cardiac condition and your perspective's changing a little. Maybe you get to a point where you don't want any medical intervention. You don't want to go to the hospital. You don't want any life-saving measures because of where your cardiac condition's at. So you work with your doctor, you update the MOLST, and it's right there on the fridge if EMS comes, so that your family, your healthcare proxy, EMS, and your doctor, everybody knows this is what Crystal's decided given her unique healthcare situation. So it's designed to be a document that grows and moves with you, and it's a medical document, medical order that you complete with your doctor. I think it's just the best thing ever because it's designed to change as our conditions change.
I would dispute one of your statements, and that is that you might, I don't think you're going to say, I don't want medical intervention. You might say, I don't want aggressive medical intervention. I don't want hospitalization.
Yeah.
But signing this does not mean I don't want medical intervention. It means I want comfort-based care. I want someone to help me stay at home. I want someone to keep me comfortable. I want pain medicine. I want support at home. I may need home health aides. I may need a variety of things. We are not abandoning them. We are not denying them medical care. We are tailoring medical care to their specific needs and wants. That means we don't put people in the hospital necessarily. We don't stick them with large needles. We don't do a lot of testing necessarily. But that doesn't mean that we're abandoning them.
100%. I couldn't agree with you more. Yeah.
Good. Thank you for that.
Yeah.
Yes.
So I have a question about the most, actually. You were discussing earlier about the inpatient or the hospital DNR and then the out-of-hospital DNR. Does this cover both? Would this, like?
I believe so. That's your understanding too, Jim.
Yeah.
Is it?
Yeah.
So I guess my question is, if we were filling this out and say my dad slips and falls, breaks a leg, something like that, but he has this filled out that he doesn't want to receive treatment in a sense, if anything were happening. Would he still be, the ambulance picked up, everything would be fine, and he would receive the care that he needed until he got to the hospital? Altering,
Oh,
so you understand what I mean?
this doesn't mean we're not going to take care of it.
Okay,
Good heavens, no.
okay.
This means we are going to tailor the care that we give to his pre-expressed desires and wishes.
Okay,
So if he falls and breaks a leg, we're going to do everything
Okay,
that pertains to that broken leg. If he falls off the roof and smashes his head and is dead, are we going to do artificial life support on him? Well, the answer is the rescue squad will.
okay.
I
I guess that was more of my question. If something happened, he was unconscious, would they do everything they could until getting to the hospital where it would be discussed based on his needs?
Unless he said in here, I do not want any of that done.
Okay,
Another thing that's very important, that travels with the patient everywhere, like we pick it up at the refrigerator, take them to Lewis County General, that patient is transferred. That pink form goes everywhere.
With them.
It goes to the receiving facility, and it goes upstairs, so it follows the patient, and that's very key.
That's why it's so easy to see.
Yeah.
That's right. So you can find it in a pile of
When you go to the
paper.
hospital, one of the first thing we ask for on the paperwork, do they have a multiple?
Yeah.
Because that directs us, and if something happens with Ruth, and it has our directions in there, they don't want anything, we just turn around and go back to Lewis County General. It says it right in the form. If you want to learn a lot about it, go on their website. They have an educational part, and it has a lot of good questions and answers on their website.
Yeah. And there are times when you would rescind in the hospital, times when you take away a do not resuscitate order. Like, for example, a woman in the nursing home who falls and breaks her hip and has an order saying do not resuscitate, no ventilators, but she has to go to the hospital operating room to get a hip, pinned or some sort of procedure. They will pause the do not resuscitate protocol while they're in the operating room getting that procedure done. And as soon as they get back to the recovery room, they will reinstitute it. So that you can provide palliative, comfort-based care to this person with a broken bone. You don't want to leave them there with a broken leg. You want to fix it. And that requires a breathing tube. So you do what you need to do, and then you reinstitute your DNR after they leave.
So what's the difference between this and a living will?
That essentially is a living will.
Okay. Is the difference that that's a medical document and a living will is a legal document?
Well, I think it's medical and legal at the same time. It says basically the same sorts of stuff.
So then this would be better to fill out than a
Yes.
living will.
Yes. They are redundant. Either one would be accepted by most people, but the system is saying that the pink one is the one to go for, increasingly with time. And hopefully soon, our electronic health record will be mature enough to be able to allow it to go to Alabama, where his car accident is. I think you're optimistic when you say that that follows you everywhere. I think the electronic health records are in their infancy and inefficient in that regard.
Sometime optimistic.
So if you were driving to Alabama, you could take it with you.
I can tell you on the ambulance, say you have surgery down in Syracuse and they're in the system. We get on our computers, we put the demographics of the patient, it boots up all the past medical history that facility has, and it's really good. It tells us what medications they're on, what allergies they have. We have it right on scene. Bravo goes to that, we'll be able to do it. Samaritan's on that system, and so is Utica.
It is the goal that will eventually be universal.
Cost money.
Yeah. And a lot of sweat and time and education. Yeah. Anything else I can add? Well, thank you. That's been very helpful. I turn it over to you.
Thank you. So just to wrap things up, we really wanted to thank everyone for coming today. It's great to have so many folks here, and I hope that you all go out into your lives and talk to friends and family about today's conversation, and be the impetus to start conversations with others about these really important subjects. I really want to thank Dr. Root and Kevin Mcardle for joining us today and sharing their expertise and their stories. Thank you both so much. We also wanted to remind everyone or let you know that at the Office for the Aging, we provide some basic legal services to people 60 and over. And right now, in much thanks to the beautiful stimulus programs that we've benefited from over the last year, we have funding to provide that service to the whole community. So within reason, of course. So anyone over the age of 60 who is interested in setting up a power of attorney can contact our office, and we work with Kevin. It also might be a great opportunity to think about other advanced planning, like setting up a will or other legal documents, but unfortunately we can only provide the power of attorney. So let folks know that that's an important service, and I know Kevin always talks to people about the healthcare proxy when he's talking about power of attorney. There's some other legal supports that we can provide too, so if you need more information about that, give us a call. Chris actually manages that program. Okay. So thank you all for coming, and stay in touch with us and enjoy the rest of your day.